First, let me give you the headline, then let's discuss the details, and then let me talk to you about where we go from here. And I actually think there's some great news to share. The headline is that the United States Supreme Court just ruled in a 6-3 decision led by the 6 right-wing Supreme Court justices that they will allow the gerrymandered Texas map to remain in place before the midterm elections. That gerrymandered map, of course, is the product of a mid-decade redistricting effort by the Texas MAGA governor, Greg Abbott, and Donald Trump, where they want to create 5 additional Republican congressional districts in Texas for the midterms by doing a further gerrymander in a state that's already very gerrymandered based on a gerrymander done at the beginning of 2020 and 2021. Now, Donald Trump and Greg Abbott's map was challenged before a district court proceeding. A 3-judge panel led by a Trump-appointed judge in Texas ruled against Donald Trump and Greg Abbott, saying that their map was unlawful. The Trump-appointed judge said that the map was clearly a product of racist gerrymandering. That judge held a multi-day hearing where evidence was presented. And the federal judge appointed by Donald Trump in 2019, who wrote this decision, said we cannot allow this map to stay in place. So Donald Trump then immediately appealed on an expedited basis to get to the Supreme Court. Justice Alito then stepped in right away. Let me help you, Donald. Let me help you, Donald. Justice Alito then issued a temporary stay and paused the district court decision, again, led by a Trump-appointed judge, that would invalidate the gerrymandered map to create these 5 additional Republican congressional seats. And then Justice Alito said there would be a more fulsome ruling later. And then this evening, Justice Alito and the right-wing Supreme Court justices in a 6-3 decision issued a more permanent stay or pause of that district court ruling and basically said that let this case go through a full trial, a full appeals process, and then you can bring it back to the Supreme Court later on. That will take many years, and as a result, the gerrymandered map will remain in place for the midterms. Now, you, of course, know that California responded immediately after Greg Abbott and Donald Trump wanted to rig the midterms and had their mid-decade redistricting plan. California said, how can we offset what they're doing in Texas? So California Governor Gavin Newsom ran Prop 50, which passed in a popular referendum. The people said, yeah, we want to do this. Overwhelmingly passed. So California then added its own congressional seats and gerrymandered in favor of Democratic seats to do a perfect offset against the Republican-created seats in Texas. Now this evening, the Speaker of the House in Virginia, by the name of Speaker Scott, Speaker of the Virginia House, Don Scott, who we've had here on the Midas Touch Network, said, you know what we may do? Now in Virginia, why don't we gerrymander Virginia to create a 10-1 advantage now that we see what the Supreme Court did? I'm going to show you that in a moment. While we're at it, though, let me just remind you to please subscribe to the Midas Touch YouTube channel. We're on our way to 6 million subscribers. You may think you're subscribed right now, but you may not actually be subscribed. We need to promote fact-based, receipt-based, deeply analyzed, legal-based YouTube channels like this and networks like the Midas Touch Network. You know we're under attack from Trump and state regime media fox. So please subscribe if you can right now. It would be a big help to us if you subscribe. So hit subscribe right now. Okay, so let me just go through the Supreme Court ruling that was issued this evening. And let me show you why, though, it actually helps what Speaker Scott's saying in Virginia that he wants to do, because, and I think this is going to backfire on what the Supreme Court did. So let me read from you the Supreme Court's decision from this evening. Greg Abbott versus League of United Latin American Citizens. Here's what it says. With an eye on the upcoming 2026 midterm elections, several states in recent months redrawn their congressional district in ways that are predicted to favor the state's dominant political party. Texas adopted the first new map. Then California responded with its own map for the stated purpose of counteracting what Texas had done. North Carolina followed suit, and other states are also considering new maps. Respondents in this case challenged the new Texas map, contending that the legislature's motive was predominantly racial. A divided 3-judge district court panel, the one that I just told you about, agreed and enjoined or blocked the use of the new map in the 2026 elections. With the 2026 campaign underway, the state of Texas and several of its officials applied to the Supreme Court for a stay to block or pause what the district court did, what a Trump-appointed judge did, who found that the Texas map was unlawful. Now, the Supreme Court says, based on our preliminary evaluation of this case, Texas satisfies the traditional criteria for interim relief. Texas is likely to succeed on the merits of its claim that the district court committed at least 2 serious errors. First, the district court failed to honor the presumption of legislative good faith by construing ambiguous, direct, and circumstantial evidence against the legislature. Second, the district court failed to draw a dispositive or near dispositive adverse inference against respondents, even though they did not produce a viable alternative map that met the state's avowedly partisan goals. So can we just pause there so you see what this right-wing Supreme Court majority, the 6-3 right-wing Supreme Court majority is saying? It's saying that the Trump-appointed district court judge failed to honor a presumption that the legislature is acting in good faith. Well, that's not true. The 3-judge panel at the district court level reviewed what the legislature did, and they said they're not acting in good faith, that they've made statements, and there was testimony and evidence elicited, that they wanted to do a racist gerrymander. And the district court judge went on to cite many instances of why the legislature was behaving in a racist manner, and how at first the legislature didn't want to do this until it colluded with Trump to come up with this racist pretext to change the maps. So the district court did make a thorough analysis there. Then it says, second, the district court failed to draw a dispositive or near dispositive adverse inference against respondents, even though they did not produce a viable alternative map. What the hell is the Supreme Court talking about? Of course there's a viable alternative map. It was the map that existed before the mid-decade redistricting. That was the viable alternative, which, by the way, that map, the one that existed, was already a horribly gerrymandered map, but that was the map that was in place. This racist gerrymandering map is what's unlawful. So do you see what the Supreme Court is setting up here? They're saying whatever the legislature does, we just need to give deference. Even if a district court judge, even if a Trump-appointed judge makes the finding through a trial that was basically held, a mini trial, that the new gerrymandered map was racist. And then they were like, well, you didn't make adverse inferences against the party challenging the racist maps when they didn't produce a viable alternative map. And they did. It was the map that existed before the racist gerrymander. You go on to read this opinion. It says, Texas has also made a strong showing of irreparable harm and that the equities and public interest favor it. This court has repeatedly emphasized that lower federal courts should ordinarily not alter the election rules on the eve of an election. Pause there. You know who's altering the election rules on the eve of the election? Not the court. The court just said, let's have the status quo. That's what the district court said. The status quo was the map before Donald Trump and Greg Abbott colluded to do the racist map. So all the district court says is, now let's do the status quo, not what you're trying to rush through unlawfully. And then the Supreme Court said, no, district court, you just have to allow whatever the legislature says. You can't question it if it's close to an election. It goes on, the Supreme Court ruling goes on to say, the district court violated that rule here. The district court improperly inserted itself into an active primary campaign, causing much confusion and upsetting the delicate federal-state balance in elections. No, it didn't. All it was saying is preserve the status quo before Donald Trump and Abbott upset the status quo right before the primaries were taking place. That's what actually went down. So then it says here, the application for stay presented to Justice Alito and referred to him by the court is granted. The order by the United States District Court for the Western District of Texas, which is led by a Trump-appointed judge, is stayed pending the timely filing of an appeal in this court, meaning let it work its way up the court for years and years and years, 5 years, 7 years, so it effectively kills the case to block this racist gerrymandered map. Okay, that's what it says here. Let me show you, though, what the dissent says, because this is important that you understand what are the liberal justices saying. So you have Justice Kagan, with whom Justice Sotomayor, and Ketanji Brown Jackson. Here's what they say together in their dissent. Over the course of 3 months, a 3-judge district court in Texas, with a Trump-appointed judge leading the way, undertook to resolve the factual dispute at issue in this application. In enacting an electoral map slanted toward Republicans, did Texas predominantly use race? Was it racist to draw its new district lines? Or said otherwise, did Texas accomplish its partisan objectives by means of a racial gerrymander? The district court, again, led by a Trump-appointed judge, conducted a 9-day hearing involving the testimony of nearly 24 witnesses and the introduction of thousands of exhibits. It sifted through the resulting factual record spanning some 3,000 pages. It assessed the credibility of each witness it had seen and heard in the courtroom, and after considering all the evidence, it held that the answer was clear. Texas largely divided its citizens along racial lines to create its new pro-Republican House map in violation of the Constitution's 14th and 15th Amendments. The court issued a 160-page opinion recounting in detail its factual findings. Yet this court, the right-wing majority of this Supreme Court, reverses that judgment based on its perusal over a holiday weekend of a cold paper record. We are a higher court than the district court, but we are not a better one when it comes to making such fact-based decisions. That is why we are supposed to use a clear error standard of review, why we are supposed to uphold the district court's decision that race-based line drawing occurred, even if we would have ruled differently, so long as it is plausible, so long as we find that the district court didn't use clear error, wasn't so outlandish in their ruling. Even if we disagree with the district court, we, the Supreme Court, are not allowed to disrupt their ruling. That's the standard, and we're not following that. Without so much as a word about that standard. The Supreme Court doesn't even address what the standard of law is here. This court today announces that Texas may run next year's election with a map the district court found to have violated all of our oft-repeated structures and strictures about the use of race in districting. Today's order disrespects the work of a district court that did everything one could ask to carry out its charge, that put aside every consideration except getting the issue before it right. And it goes on to say, and today's decision deserves a lot of condemnation. So you go on to the end and it says, this court's eagerness to placate, or to play act, rather, this court's eagerness to play act a district court has serious consequences. The majority calls its evaluation of this case preliminary. The results, though, will be anything but. This court's stay guarantees that Texas's new map, with all its enhanced partisan advantage, will govern next year's elections for the House. And this court's stay ensures that many Texas citizens, for no good reason, will be placed in electoral districts because of their race. And that result, as this court has pronounced year in and year out, is a violation of the Constitution. It is. Powerful dissent. So then in Virginia, they're like, okay, great. The Democratic speaker, Don Scott, said, okay, why would we even just try to pick up 3 seats? Let's do a 10-1 gerrymander right now. Let's not even make it close because the Supreme Court's saying that they're not even going to look at it. So why don't we do that? This is powerful stuff. Here's what Virginia House Speaker Don Scott had to say. Play the clip.
Now it's 6-5 Democrats, 6 Democrats, 5 Republicans. 10-1 is not out of the realm. And I think, you laugh. I'm not joking.
I think it's
no, 10-1 is not out of the realm to be able to draw the maps in a succinct, community-based way. But we're going to take a look at it.
Well, there you have it, folks. Let me know what you think. Hit subscribe. Let's get